Mr Speaker, the bill that's under consideration in this session was introduced by the previous Labor government, and as a result, members on this side of the House intend to continue their support for the legislation. So the bill will address two problems that currently exist in the Privacy Act. The current Act doesn't allow foreign nationals who are resident overseas to make information privacy requests for information that's held in New Zealand, and the Act does nothing to prevent data received from overseas being transferred out of New Zealand to another jurisdiction without there being adequate privacy protection. Two obvious flaws that have come about as a result of the increased flow of both people across borders and information across borders since the enactment of the original legislation, and a perfect example of the sort of problem that arises over time that this Parliament needs to update and address so that the commercial and the human rights concerns that arise out of those flaws can be properly addressed. So there's a real business benefit as well as a personal benefit for people who will benefit from the loopholes that are closed by this legislation. Once this legislation is passed, we will be able to better demonstrate in international negotiations that information stored in New Zealand or in respect of persons and businesses with which New Zealand has a connection is secure, and that has got to be a good thing for New Zealand business. The bill complements the Law Commission's review of privacy laws. The Commission has recommended enacting a Surveillance Devices Act, which will make New Zealand privacy laws more consistent, make it an offence to secretly film or track people. So there is more work to do in this area, but we are starting at least to fulfil some of the recommendations of the Commission by getting on with this legislation today. And really it's important, I think, sir, to see the legislation in the context of much of the other law that this Parliament has dealt with in the past couple of days under urgency. This legislation is an important part of the continuation of the business-friendly program that the last Labor government was enacting to ensure that there was not excessive red tape, to ensure that our laws were up to date so that businesses and individuals could feel confident about that level of sophistication in our legal system. And so it is good to see Parliament finally progressing the international privacy legislation through its final stages. So the Justice and Electoral Select Committee's main concern, as is apparent from their report related to the OECD guidelines concerning privacy, those guidelines are of extreme importance to New Zealand given our membership of the OECD. Due to the way that the guidelines had originally been incorporated into the bill, any changes by the OECD to the guidelines would have been automatically incorporated into the legislation. That is, changes made by a foreign organisation, an organisation comprising other countries as well, would have simply resulted in an automatic change to New Zealand law without any examination by this Parliament. And so the committee had a look at that. It took some advice from the Regulations Review Committee, as I recall, and the committee in the end recommended that the basic principles of national application should be set out in a schedule to the Act, that the Governor-General be given the power to make regulations to amend the new schedule in the event that the OECD did make new guidelines, and that that any changes to the schedule as a result of that OECD activity would be subject to the Regulations Disallowance Act 1989 and thereby scrutinised by Parliament in the event that it was necessary. So there was a proper framework put in place on an incorporation by reference clause to ensure that parliamentary oversight of any amendments would be proper and in keeping with our constitutional traditions. It's good to see that the committee's report is being incorporated as far as those recommendations are concerned in the bill. The committee also recommended that it be made absolutely explicit in the legislation that when determining whether to prohibit any transfer of personal information, the Privacy Commissioner should use the investigative powers in the Privacy Act if she felt the need to, just as she can when conducting an inquiry under the Act. So the Commissioner will be able to hear information from any person that he or she considers necessary in the event that seems the right thing to do. So the committee process has clearly improved the legislation. We've got proper scrutiny by Parliament of any changes incorporated from the OECD, and we've got an enhancement of the Privacy Commissioner's authority consistent with their general jurisdiction. So, Sir, members on this side will support the legislation. It is good to see the rest of Leanne Dalzell's program as former Minister of Commerce and Justice being implemented by this House. Just had an interjection from a minister who has no respect for anybody's privacy in this country, so it's rather ironic that she decides to speak out about an international privacy matter, but we'll let that one go. The other issue, Sir, that needs to be pointed to is that we had the Select Committee report back on the 30th of September 2009. It is a shame that this government doesn't think that this sort of red tape cutting, good pro-business legislation is important enough to progress more quickly. We've had to wait since September last year, since the committee reported, to actually see the legislation back into the House. So I don't know why, as David Cunliffe says, members opposite are so anti-business, and why we have to put up with symbolism, tokenism and dog whistle laws like the Fire at Will Bill, which is trumpeted as pro-business legislation, when in reality this is the sort of thing that will make New Zealand businesses more productive and more competitive. On that basis, Sir, despite the lamentable delay in progressing it, I do commend the bill to the House.
Chester Borrows.